Hello, everyone, and welcome to our monthly webinar, 10 Ways Estate Planning Can Save You Money. We're going to wait just a moment here to see if anyone else trickles in. And throughout the webinar, you can ask questions in the chat. I may not see it until the very end, but that is absolutely okay. Just go ahead and ask your questions so you don't forget them. And I will answer as many as I can at the very end. Okay, let's see if we've got anybody else in the waiting room. Okay, let's go ahead and get started. So for the next hour, I'm going to share with you all of the secrets of estate planning. They're not so secret, but I think there are a lot of misconceptions out there. So my goal with this webinar is to leave you with a better understanding of what can go wrong if you don't have any estate planning in place and what documents you need and how to get them in place so you can make informed decisions about what's best for you and your family. And like I said before, ask questions in the chat as we go, and at the end, I'll answer as many as I can. So today we're going to talk about ways estate planning can save you money, but we'll also talk about why it's important to do this even if you aren't a millionaire. During today's presentation, I want you to think about why you're interested in estate planning and who are you doing this for? So before we get to the good stuff, here is a little bit about me. I'm Stephanie Emel Nelson, and I'm an estate planning attorney with Jennifer Porter Law. We are a military spouse-owned firm based in Northern Virginia and Hampton Roads. I've been a practicing Virginia attorney for 23 years, and I'm licensed in Virginia and DC. I am also a retired military spouse. My husband is retired from the Navy. And here is all of my contact information. You can screenshot this or take a photo or use the QR code to save my info. And please feel free to give me a call or email me if you have any questions after this, or if you're not comfortable asking questions in the chat. So just like many of you, my reason for being here and for doing this is my family. I live in Virginia with my husband, retired from the Navy, and our 3 boys. Our oldest is off at college at Virginia Tech, and our middle is at William and Mary, and our youngest is 10 going on 20, as you can see from this photo. We're in full early tweenitude. My husband and I, we both have aging parents and college expenses, and we're trying to save for retirement. And we also have to worry about, what happens to our youngest. We want to make sure that he is cared for if something happens to us. So I get it. I know how overwhelming it is and how hard it can be to know, where do I start? So today I'm going to show you how to start planning. So first, I have a question for everyone here, and this is a no judgment zone. Do you have an estate plan in place right now? Now, I realize that estate planning is not something that's really fun to think about. In fact, almost 70% of Americans don't have any estate plan at all. So if you are one of those 70%, you are in very good company. So, and at the end of the day, when I talk about estate planning, the big picture here is that it's not really about you and it's not about me. It's about the people we love the most. So my definition of estate planning is making sure that things are as easy and inexpensive as possible for your loved ones when you're gone. And you care about that, whether you're 25 or 85, and you care about that no matter how much money you have, $100 or $10 million. So as we go through this presentation, I'd like you to think about the people you love the most. Now, if you're the parent of a minor child, another important reason to plan is to ensure that your kids are cared for if something happens to you. If you have minor children, that is kids under the age of 18, one of your top priorities should be getting in writing who you want raising your children should something happen to you and your spouse or partner. In fact, I think for parents of minor children, estate planning is even more important than it is for someone who's older, retirement age, or looking at health conditions, because there is nothing more important than making sure your kids are taken care of by the people you want the way you want, no matter what. So if you haven't named guardians in a will and you and your partner or spouse pass away, a judge is going to decide for you. In other words, a complete stranger will decide who gets permanent custody of your children. And because you didn't get your wishes down in writing, they have no choice but to figure out who you would have wanted on their own. And don't get me wrong, every judge does the absolute best job they can with the information they have, but they don't know your family. They don't know your preferences. They don't know your values, and they don't know what you would have wanted. So your children could end up with someone who looks really good on paper, but maybe isn't the best person, or sometimes it's even the last person you would have chosen to raise your children. This is something that happens in something called a permanent guardianship proceeding. Now, this whole process is expensive and it can be grueling emotionally, and you don't want to put your family through this. So you may have just said a few minutes ago, no, I don't have an estate plan. At least you think that you don't because you haven't formally done a will or a trust. But the truth is that you do have an estate plan, even without formal documents. It's just that the Commonwealth of Virginia has written it for you. In other words, there are default rules that kick in when someone dies without doing estate planning, if they die intestate. You probably won't like those default rules, which is why we do estate planning. So we can override this for your family and your assets, and you can make these important decisions yourself instead of letting Virginia make them for you. So what happens if you do die intestate? Well, your assets are going to be distributed according to state law, and they may not end up where you wanted them to go. Your kids are going to get their inheritance at age 18 and outright, and that can be a nightmare. Young adults often just simply aren't ready to handle the kind of money that they can get from an insurance policy or a retirement account. And so it's a good idea to put boundaries in place for them. You could also end up with your spouse remarrying after death and leaving money to a new spouse and kids. It happens all the time. It's usually not malicious. It just happens. You know, you pass away without a will, everything goes to your husband, of course, as it should. Um, and then husband gets remarried. Maybe he has more children, maybe not, but he's never done any estate planning. And then when he passes away, his wife gets a big chunk of it. So, you know, that's just something to think about that most people don't really think about until it's too late. Also, a judge is going to decide who will raise your minor children. We just talked about that. They're also going to decide who will control the money that you leave them. And your family is going to have to go through a stressful, costly process that can take anywhere from 8 months to a year. In Virginia, it's probably more like 12 to 18 months before your family can get your assets. So first of all, when I talk about an estate, what the heck does that mean? So many of us don't think that we have an estate. Only really wealthy people have those. But we all have some of these assets or accounts, including, you know, checking and savings. You may have a house. You could have a business, a small business. You've got retirement accounts, life insurance. You may have a brokerage account, and you have a lot of other things as well. You know, you may have a car. You may have a lot of really nice furniture. You could have artwork. All of this makes up your estate. And we need to decide where all of this is going to go when we pass away and under what circumstances. So let's talk about the saving money part, because this is 10 ways that estate planning can save you money. First up, we can use estate planning to minimize estate taxes. Nobody wants to pay more than their fair share, right? I mean, come on. And with careful estate planning, we can make sure that your heirs get as much of your money as possible. Number two, we can avoid probate costs. If you don't have an estate plan, or if you just have a will, your family is going through probate. You can't avoid it. When you pass away, probate it is. In Virginia, this can cost anywhere from 1% to 7% of your estate to get through probate. And if you just do a little math in your head right now, you can see that that adds up quickly. But again, with careful estate planning, we can avoid the costs of probate. Protecting your assets from creditors. If you're concerned about getting sued, estate planning can help protect some of your assets. But often clients come to me concerned about protecting their kids' inheritance down the road. So whether it's a bad marriage, a high-risk career, drug and alcohol abuse, we can make plans to protect your kids' inheritance with estate planning. Keeping the family harmony. I can't say how expensive it can be when families start fighting. When you don't have a plan, sometimes families end up in court, whether it's something over who gets mom's wedding ring or whether one of the kids can buy the house. Fights happen. People think things aren't fair. It can be a very emotional time. But if you create a comprehensive estate plan that clearly states your wishes and makes it legally binding, you can avoid costly delays and litigation in court. And trust me, litigation is expensive. You don't want to end up there. Planning for long-term care. So if your loved one is looking at long-term care down the road, estate planning can help. If mom is diagnosed with a chronic illness and you know she's going to need expensive care at some point, we can help plan for that and minimize the assets that your family may have to spend or lose to long-term care. Okay, maximizing retirement savings. This is a big one, and this is one that a lot of people don't know about. Estate planning can help maximize the amount of your retirement savings that goes to your heirs, saving tens of thousands and sometimes even hundreds of thousands of dollars in taxes. There are some new IRS regulations about when and how fast your kids have to take money out of your retirement accounts when they inherit them. And this can have devastating tax consequences for your beneficiaries if you haven't planned or if you've tried to plan with a DIY will or trust. Often people just don't know what they don't know, but careful estate planning can ensure that your retirement assets are passed on in the most tax efficient way possible. Okay, reducing legal costs. I talked about litigation and how expensive it can be, but fighting over a will or DIY trust is horrible. When you have to do it in court, it's horrible and it's expensive. But thoughtful and knowledgeable estate planning can ensure you have powers of attorney in place and cover situations you haven't even thought about. If we've got careful, clear language, we can make sure your wishes are followed and minimize the possibility of expensive legal challenges. Okay, asset distribution can get complicated if nobody knows what you wanted. Estate planning makes your wishes clear, and it can help you avoid probate in many cases. And this means your beneficiaries will get things more quickly and in a cost-effective manner. Business. Okay, if you own a business, this can end up in probate too. So it's important to engage in business succession planning and to ensure your business passes to the people you want quickly and efficiently. And estate planning can help you, and it can help this entire process of business succession planning and ensuring that your business interests go to the people that you want. Now, conservatorship. None of us like to think about this, but if you pass away while your kids are young and no estate planning in place, the court is going to need to appoint a conservator to be in charge of their money. This is on top of a guardian who's got custody of them. This is the person who's going to be in charge of their money. And on top of that, the court is going to oversee that conservatorship until the kids reach 18. This is expensive, and frankly, it is a pain in the butt. But with estate planning, we can avoid this. Okay, so now I hope that everyone sees that it's important to have an estate plan no matter what assets you have. So what are your options? And as we go through the two options, I want you to be thinking about which one makes sense for you and for your family. So here are your two basic options. You're either going to do a will-based plan or a living trust-based plan. And this is a decision everyone has to make, whether you're married or single, kids or no kids, doesn't matter how much money you have, you want to decide if you want a will or a trust. And probably about 80% of my clients end up using a trust. So first, let's look at a will. What does a will accomplish? Now, having a will is definitely better than having nothing in place for sure. You get a gold star if you've got a will in place already. This is where you name guardians for your minor kids. And you can also name beneficiaries for any asset or account held in your name alone. And you can name an executor, and this is the person who's in charge of wrapping up your affairs and your estate when you're gone. But that is about all that you can do with a will. The benefit of a will is that it's easy to understand. Everybody knows what a will is, and we all know what an executor does. At least we kind of have an idea, right, from TV and movies and all of that. Unfortunately, a will also comes with some downsides that most people aren't aware of. So we're going to talk about that next. Okay, the downsides of a will. First, as I mentioned before, wills must go through probate court at your death if you have more than $50,000 in assets. And we're going to talk about why this can be a bad thing in a few minutes. So your will is also only effective at your death. So it doesn't help at all if you're alive but incapacitated and unable to manage your own affairs. What happens if you're sick or in an accident and you can't manage your finances? Your will is not going to help someone step in those circumstances. And that's going to happen to a lot of us at some point in our lives. Another problem is that each state has their own laws regarding wills. So a Virginia will may not be effective in California. There are different laws about how property can be inherited and what has to happen and how a will has to be executed. So if you move to Florida from Virginia, then your will may not be effective anymore, and you may need to redo that will or the rest of your estate plan. And the last part is a really big one. There's no direction or protection long term after your death. And most parents don't want their kids to inherit everything when they turn 18, which is the age you can legally inherit money in Virginia. Most parents want their kids to get it later in life when they're a little more mature. And you're not really allowed to put instructions in a will that says my kid can only inherit when they're 25 and have finished their education. You can't do that with a will. You would need a trust to put those sorts of conditions on inheriting. And like I said before, a lot of your assets are outside of the reach of a will and don't go planned for. Anything that you have jointly or with a direct beneficiary is not going to go through probate. It's not part of your probate estate, and a will can't control where those go. So that includes things like a lot of property that's owned jointly, retirement plans, annuities, insurance policies, pretty much anything that's held jointly with someone else. And finally, a will simply transfers property at death. So you can say, I want my money to go to my daughter when I pass away, but you can't say when she's 25 and has finished college. You can't really put any of those instructions in there. You need a trust to do that. Okay, let's talk a little bit about probate. So if you've got a will, it must go through probate court if you have more than $50,000 in assets before your money can be distributed to your family. And while your court experience probably won't be as traumatizing as Colonel Jessup's, it's not going to be all that pleasant either, because court is never really a fun process for anyone. And as a former litigator, just trust me on that one, okay? So a major downside to probate is that it can also take a long time. Even a really simple estate can take months or years to probate, and the minimum in Virginia is typically 6 months, but for most people, it's 12 to 18 months. And that's assuming that everyone cooperates. There are a lot of times when someone does not cooperate. Whoever gets named as executor just decides not to do anything, or they just try to take the money and hope nobody's going to contest it. But while all of this is happening, your assets are frozen for the duration, which is a really big problem if you're counting on that money being available for the care of your minor children. And it's a really big emotional burden for your family, sort of dragging this process of settling your affairs out over several years. Probate can also be expensive. There are court fees, legal fees, executor fees, and they can eat up as much as 1 to 7% of the estate assets. And those fees are going to reduce the amount of money that ultimately goes to your family. So what is probate court? Because I keep talking about probate. What is it? Basically, the main purpose of probate is to change the title on the property you own when you die from you to your family. So you do a full inventory of assets and an appraisal of each asset. If anyone contests the will, those disputes happen in probate court, and then those assets are distributed to the beneficiaries. And a judge oversees this whole process, and you need court permission to do pretty much anything. And your family will often need to hire a lawyer because it's a complex process. So let's look at an example here. This is Rebecca. Rebecca is a single woman. She's created a will that leaves everything to her daughter, Megan. Gold star. She's done her adulting. She's got a will in place. Yay. Megan is currently 10 years old. Rebecca has a house that she lives in worth 400,000 and also a house she rents out that's worth 100,000. She's also got an investment account with 250K. She has life insurance payable to a minor and a retirement account payable to a minor. She's got Megan as her direct beneficiary. And because minors cannot inherit property under the age of 18, these assets now have to go through probate. So a judge can make sure the money is being handled properly. So these assets are now part of the probate estate. So when we add all these assets up, the total probate estate is 1.8 million. And remember how I said earlier that probate can cost anywhere from 1 to 7% of the probate estate. When Rebecca dies, her will leaving everything to Megan will need to go to probate court. Her family will have to hire a lawyer to probate the will. And let's say it only ends up costing 2% of the total estate, even with the conservatorship for a minor. That's still $36,000 lost in probate. And to be honest, it's probably going to be more than that. It's probably going to be more like $72,000. And that's $72,000 that is not going to Megan. It's going to lawyers, to the court, and probate fees. So I know at this point, a lot of people ask me, with all of these downsides, why does anybody do a will? And I am asked this all the time. And the answer is that if you have less than $50,000 in assets when you pass away, you can use a very simplified probate process that's easy and inexpensive. So in that case, a will might be sufficient. Or I've had clients who have done other advanced planning to avoid probate already and just aren't really concerned with having some of their assets pass through probate. I've had clients who've left literally everything to charity. And in that case, they're not necessarily concerned about how long it's going to take or how much it's going to cost to get through probate. But for most people, if you have more than $50,000 and you want to avoid any of those downsides that we just talked about, a will may not be the best choice for your family. And I know a lot of you are probably going, so if I'm not going to use a will, if that's not going to do what I want it to do, what do I do? So let's look at your second option, and that is something called a revocable living trust. And again, this is the option that probably 90% of my clients end up choosing. So what is a revocable living trust? I like to call it a will on steroids. It's a document that you're going to create that's really similar to a will. You'll list all the people you want to inherit your money when you're gone. And just like a will, a trust is revocable. That means you can change it, you can rip it up, you can revoke it entirely at any time. And your revocable living trust is going to have a trustee, and that's you. While you're alive, you're the trustee. You're in charge of both the trust document itself and the assets that go into the trust. But most importantly, a trust does not have to go through probate. So that's the big one right there. So examples, because I love examples. Let's look at Bob. He has $100,000 in a bank account that he wants to go to his son Fred when he dies. But he wants Fred to be 25 and has finished college before getting the money. For Bob, college education is very important. Bob needs a trust. He's not wealthy. He's not setting up a fancy trust because he's got millions to leave behind. He just wants Fred to be 25 before he inherits. He wants to put some rules in place. He needs a trust. Even though he doesn't have a lot of money or a complicated estate, he needs a trust because he wants to control how and when his son gets his inheritance. That's it. So every trust has three roles. It's got a grantor, or sometimes called a settlor. This is the person who contributes assets to the trust. A trustee, and this is the person who manages the trust assets, and a beneficiary, and that is the person who is entitled to those assets. And with a revocable living trust, you hold all three positions while you're alive. You're the grantor, the trustee, and the beneficiary. So let's look at another example here. Harry and Wendy. Harry for husband, Wendy for wife. Now, Harry and Wendy set up a revocable living trust and they occupy all three positions. They have total control. They act as the grantors who created the trust and transferred title to their assets. They occupy the manager's role as trustees and they make all the decisions over the trust assets. And then finally, they're also the beneficiaries of the trust because they have the right to spend and use the trust assets any way they want. In other words, Harry and Wendy still have complete control over their assets, even though the assets are titled in their trust. And what does it mean to be in total control? It's business as usual for Harry and Wendy. They pay taxes the same way, they pay their bills the same way, and they can amend their trust or even revoke it if they want to. They have all the rights to manage the property. Their income tax forms are filed exactly the same way they've always done them with their social security numbers, and their property taxes are paid the same way as well. And because this is a revocable trust, the government just ignores the trust for tax purposes and continues to tax Harry and Wendy as individuals. So with a revocable living trust, the secret to avoiding probate is how you hold title to your assets. Now, assets can be owned individually, jointly, or with a beneficiary designation. And how we title our assets is important with a revocable living trust. So think of a revocable living trust as like a kid's backpack. When your kids start school, you let them pick out a backpack and it can be any kind, any color, any size. There's a million different options out there. The Pikachu backpack, the princess backpack, the Barbie backpack. Your trust is the same way. You set it up so it accomplishes what you want it to accomplish. And the goal is to have your trust hold all of those assets because then the assets are going to be distributed according to the terms of the trust when you pass away. So a trust also solves all the problems that come with a will. You're not going to lose 1 to 7% of your estate in probate court. It is much less expensive to settle a trust estate, particularly if it's a simple one. Your assets can go to your family in weeks and months instead of years, and it is totally private during life and at death. Wills are public documents, and anyone can go down to the courthouse and look them up. And they do, trust me. So some of the other benefits of a living trust are that it's pretty easy to amend. As your life changes, you're going to make changes to the trust document pretty easily. There's no separate tax identity, so your income taxes don't change at all. And your trust can cover all of your property, including beneficiary assets and jointly held assets. And it's really no more difficult to create and maintain a living trust than it is a will. It's also valid in all 50 states, so you won't have to redo your estate plan every time you move. And because it's a private document, nobody knows what's in it. So it's hard to contest, and you don't have some of those, fraudulent things that pop up after people go and look up your will in the court. And okay, let's talk about this because I get asked all the time, even by family members who should know better. Why can't I just pay $400 for an online trust? Isn't that the same thing? Well, DIY is great for crafts, but I would not recommend tearing out walls and trying to fix your own electricity. And it is the same for estate planning. Only the people who are going to get electrocuted are your family after you pass away. The online drafted trusts and wills I've seen, and I have seen quite a few, they often don't even comply with state law. They're almost always not personalized to specific family concerns. People will say, but I thought that mom and dad said that they wanted their trust that they did online to do X, Y, or Z. Doesn't it do that? And unfortunately, most of the time the answer is no, it doesn't. And they're also often not funded properly. So having a trust is great, but if you don't put your assets in the trust, they're still going through probate when you pass away. Some of the DIY trusts that I've seen even have conflicting provisions, which is a recipe for ending up in expensive litigation. And remember when I said earlier that your heirs could end up with devastating tax consequences depending on how your trust is drafted? Yeah, that right there. It happens all the time. A better idea is to work with an experienced estate planning attorney. And here's what I want you to remember. When you work with an attorney, you are paying for guidance and counseling about how the documents should be drafted, not the documents themselves. At our law firm, we have flipped the traditional experience on its head. We do not bill by the hour. Everything I do for estate planning clients is flat fee and it's agreed to in advance. So you don't have to worry about being charged for, that one 5-minute phone call you made or the questions that you have or every email that you send because we don't keep track of our time. You might have a million questions about your plan, and I promise you, I've had clients who do, and it's all part of your flat fee. It's expected. And, I don't want you to be concerned with whether or not you can ask questions because you're going to get charged for it. I want you to know and understand how your estate plan works. Excuse me. Also, I really love creating estate plans for my clients because it's really proactive. I'm not responding to negative situations. It's all about making sure your family isn't going to have to deal with an expensive mess when you're gone. And I really do value relationships with our clients. Our entire firm does. We want to stay in touch with you over time because we know that your estate plan is not something you're going to do once and then never think about again. Your life is going to change and the law is going to change, and we want your plan to keep up with that. So how do you get started? So this slide right here, this is our virtual estate planning process. And we can do virtually everything virtually except your signing meeting. So the first step is you attend a peace of mind planning session, which is a one-on-one consultation with me, and it lasts about an hour. This is $400, but we apply this $400 towards any estate planning work that we do for you. Before the session, I have you fill out an online questionnaire called your family profile before the meeting. And this asks you questions about your family, your values, and your assets. So we can start to gather the information we need to draft your plan, to create your plan. And in your planning session, I'll hear more about your goals and concerns, and we'll look at your personal and financial situation, and I explain your options thoroughly. And then you can make the best choice for your family. After you've decided to hire us for estate planning, we have a design meeting where we actually sit down and design your estate plan with you. And then I draft your documents and I send them to you for your review, and we meet again to go over them. You can ask questions, we can make adjustments, and I explain what everything means and does in plain English. And then once we finalized your documents, you pick a date to sign everything, and we typically do that in person at one of our offices in Fairfax or in Norfolk. And sometimes I go to nursing homes. We can be flexible, but we do the signing in person for the most part. And now you have a legally valid estate plan. Congrats. Yay. So after that, we'll also invite you to keep in touch with us, and we'll send you information from time to time about estate planning. And we'll ask you to check in when you have major changes in your life. If you get married, get divorced, you have a really big increase in income, you start a business, win the lottery, it might be time to adjust your estate plan. But either way, you should reassess your estate plan and everything you've done, all of the agents you've chosen, at least every 5 years. And if you have changes to make, we can do that for you too, and quote you a fee at that time based on your needs. Okay, let's talk about fees. I know it's something everybody wants to know. Bargains are good when you're shopping for paper towels, but going cheap on a parachute, a surgeon, or a fire extinguisher is typically not a good idea. So estate planning is like anything else. You get what you pay for, and it's worth it to make the investment to get it done right. And frankly, not planning is going to cost you a lot more than working with an attorney. So let's look at what this should cost your family. If you plan for, my average client with a modest estate, even with just a house worth $500,000 and minor children, you could save anywhere from $20,000 to $25,000 in probate and conservatorship fees after death. And it can also save your children from losing their inheritance down the line. We can do asset protection. We can plan for taxes. We talked about all that at the beginning, the 10 ways that estate planning can save you money. But estate planning should also ultimately save you money. If it's not going to save you money, then there's not much point, is there, right? And it's also about making the lives of your loved ones easier when you go. So the next step is to book your peace of mind planning session. And you can do that by calling our firm or emailing me. And I or one of our paralegals can set up a time for your Zoom planning session. And if you have any questions at all about our process or packages or fees or anything like that, feel free to call or email me. And you can also set up a 10 to 15-minute call with me before proceeding as well. And that is free. So here you've got all of my information, and go ahead and call or email me directly, and I'm happy to help. We also have an online form on our website if you prefer to do that. Sometimes it's easier than trying to pick up the phone. If you're anything like me, you think about something you should have done at 2 a.m. and you can't call anyone. So there is that option, and you could always send me an email. So that is it for the webinar today, but I am going to take a few questions because I see that we have a couple. And let's see here. The first question is, what is the difference between a revocable and an irrevocable trust? That is a good question. So today we talked about revocable trusts. And a revocable trust, like I said earlier, it's one that you can revoke. You can change it. You can change the beneficiaries. You can change anything about it. You can move assets in and out. With an irrevocable trust, you cannot. Once the assets are in there, they're not going anywhere. You can't typically change the terms of the trust. And we use that a lot for tax planning, asset protection, Medicaid planning. There are a million different types of trusts out there. But typically it's a way to protect with an irrevocable trust, but it's one that you can't change. I hope that answers that question. What if we want to make changes? Well, I can do that, and I do it for my clients often. If you have a trust, we can restate it. If it's something minor, it's usually not much. If you want to restructure everything because you've had a huge windfall, then it could be more expensive. But we always tell you, like I always give you after I talk to you and I know exactly what the scope of the changes are, then I let you know how much it's going to be ahead of time because we still only do a flat fee. Let's see. Okay, I think I've gotten everything. But like I said, of course, if you have any additional questions and you're not comfortable asking them on the chat, then just go ahead and send me an email or give me a call, and I am happy to help. And that's going to be it for tonight. And join us again. We'll have another webinar coming up in January. And I hope everyone has a wonderful Thanksgiving. Thank you all. Good night.